I wouldn't describe it as a contract.
Okay.
I would describe it as a compact. A contract suggests it's an arrangement between private parties. This is a public thing, and it's much more than a legal arrangement. It is all about good faith. It's all about a constitutional position, much of which is not found in the law. As a person who's spent a fair bit of time on international law and constitutional law, I regard the term sovereignty as highly misleading, extremely ambiguous, and not at all useful. And so a lot of international law is based on the idea of sovereignty, that is to say, a nation, since the Westphalian kind of settlement had a certain lot of characteristics. But you know, in the modern interconnected world, the word sovereignty is pretty useless because we have so many interconnected arrangements. We can't even fly to Australia without an international organisation called the International Civil Aviation Organisation having authority. We've ceded a lot of what was traditionally regarded as sovereignty. Sovereignty is a pretty out-of-date concept. Well, I think that the treaty has to be regarded, as Lord Cook said, as New Zealand's founding document. It therefore has enormous constitutional significance because the moral authority of the government depends on it. And so when you look at it that way, it has to have a big part to play in New Zealand's constitutional arrangements, and it does. But in terms of its present legal status, it's half in and half out of the legal system. Part of it is recognised by about 30 statutes, but the law at present in New Zealand is that unless it is incorporated in a statute, it is not part of our law. But put that statement on one side and think of this. You really shouldn't look at this as something that the courts do, although the courts in recent years have been very active. The Parliament and the executive branch of government, that is to say the Cabinet, there's a Cabinet committee that deals with these matters. There's been one for more than 20 years. There have been enormous numbers of settlements go through that system. And this government has been particularly active and good at procuring those settlements. I take my hat off to Christopher Finlayson, who's been doing those negotiations. He's been very successful. I also think that you have to remember that actually it's those organs of government that are the prime ones for advancing this matter, not the courts. And people don't know really how active the executive government has been on these matters. And that has not always been the case, though, because way back in 1975, people thought the treaty was kind of dead. And at that time, the Waitangi Tribunal was established, and the treaty began to flourish in a series of reports that were not legally binding. Principles began to be developed, and constitutional principles were developed, and they seeped into the body politic and seeped into the system. And so this is a subtle, nuanced, complicated process. And while I know it's very difficult for people to understand all that, we have arrived, I think, at a situation after a few hiccups, because sometimes people spend their lives campaigning in New Zealand on the basis of one law for all, which is a simplistic and quite misleading label. to try and suggest that Maori are getting preferences. But if you look at it seriously, you have to say that when the indigenous people who were living here and the British came, the British Colonial Office felt that squeamish about simply doing nothing about that, which is why they were instructed in a remarkable set of instructions that came from the Colonial Office to ensure that it was done with the consent of Maori. And they were pretty assiduous and industrious in securing that consent. Now, it's all very well to say now that it should not be like that. That is the way it was. You cannot renounce your own historical heritage. And so that is why the treaty is central to New Zealand's constitutional arrangements, whether it's recognised in the courts or whether it isn't. And of course, in the state-owned enterprises case, in Section 9, that led to the Great Lands case, because the treaty had been recognised through the Waitangi Tribunal, and because the Waitangi Tribunal's jurisdiction was extended to look at historical grievances of the settler governments, of which there were many, enormous land confiscations, which were unjust and wrong, and were done through the Parliament after 1852 when we secured self-government, that had to be set right. I remember when I got into politics in the late 1970s, Maori was saying the treaty was a fraud. They're not saying that now. And I think the time has come for a further step and development to tidy this up and make it certain what the status of the treaty is. If you look at the Supreme Court's decision in the water case, where the partial privatisation was undertaken of the some electricity state-owned enterprises, the court said this is valid, but remember, if further steps are taken and Maori rights are taken away, there may be redress under the law as it is for that. So I think after all the experiences we've had now, the time has come to take a further step and to change New Zealand's constitutional arrangements so they are less uncertain than they are now. Our constitution evolves with political developments. It is a political constitution and it has very few firm anchors, and it morphs as you watch it. I think it would be better if we had a written, codified constitution that included the treaty. It's unthinkable that if we had a proper constitution in New Zealand that it would not include the treaty. And New Zealand is a constitutionally pretty primitive country. We are the only, Britain and ourselves and Israel to a degree, are the only countries in the world without codified written constitutions. Now, we live in a situation here where New Zealanders never think of the Constitution. You can't get a public discussion about it. There have been in the last 20 years or so 2 official inquiries into it, none of which have resulted in any change. And in a funny sort of a way, there's a sort of view in New Zealand that you don't want to say too much about these matters because we don't agree on them. And if there are sort of divisions of opinion, you want to run away from them. You don't want to confront them. Well, I think a lot of the trouble with the treaty in New Zealand flows from a lack of understanding of the people who live here about what the history is, about what happened, about the manifold injustices that were visited upon Maori and the failure to do anything about them. And you have to say that that is a stain on our reputation as a nation. Now, having said that, I do want to say that our race relations are better than most countries that I am familiar with, and we are still working at them. No, I think that you get on better if things are known, if things are open, if things are transparent. The word partnership came from the great Maori council cases of the 1980s. It was brought into our political lexicon by Lord Cook's decisions in those cases. And it is a useful concept, but it's probably a bit misleading as well, because it's not an equal partnership. And one of the difficulties about it is that whenever you characterise the treaty, you run up against a whole range of what I would call difficulties about the meanings of words. We've just had one about sovereignty, but you get it with the word partnership in the same way. And so the problem that you've got here is that it's a bit too smoky. We're not quite sure what we're talking about. And there needs to be some limits and barriers and certainty put around the nature of the treaty and what it means today. I mean, we always say in New Zealand that the treaty always speaks. It speaks today as it did 150 years ago. But it's the way in which it has ebbed and flowed in terms of New Zealand history is quite remarkable. At various times it's been pilloried and not, I mean, there was a judge who called it a nullity in 1877. So, you have to think that this is extremely complex and it's hard to make simple. But in the final analysis, it goes to the nature of our identity as a nation. Well, that's partly because we don't have a constitution. They can't read it anywhere. We've one of the most obscure constitutions in the world. It's in various statutes. It's in English statutes. It's in prerogative instruments. It's in all sorts of strange places. It's in the standing orders of the House. You can't find it. You don't know what it is. And it makes it very difficult to educate people about what it is. I've had whole lots of discussions with social studies teachers about how they should approach this. Most countries, in schools, they teach the Constitution. You can't do that here. You can't find it. That's a failure of education. It's a common failure in the system, and it's not just about the treaty. It goes to every element of our government. It goes to every element about how cabinet government works, about how the parliament works, about what caucus is. We have an extremely low level of civic virtue in New Zealand, and we have a lot of ignorance about how the system works. And I don't know why that is, because it's not true in most places. And therefore all this becomes a great mystery, and no one can be bothered with it. And that's a real problem. I tell you that when I got a very good education in secondary school, we didn't study a line of New Zealand history. We studied all about Edward I and the Tudors and all this English constitutional history that I had for years and years, and nothing about New Zealand at all. When I got to the university, I was looked around for a New Zealand history course. There wasn't one. It started shortly after that. But you see, this is such a young country that although now it has a longish sort of history and we're one of the world's oldest democracies, we don't really know much about ourselves. And going back to what you said at the beginning of this question line about all these cliches about how we puff ourselves up and think we're so good, New Zealand is a very small, obscure nation, and you have to face that reality. People do not know about it, and we don't know about it either. The historical grievances are coming to an end, but that's looking back to injustices that are being remedied. What about future injustices that may occur? And they do occur. And Māori became quite agitated about this water question, and that question is not resolved yet. And it will be very difficult to resolve. But you see, the problem is this, that if the treaty always speaks, it's going to go on speaking. It's not going to stop speaking. Well, I think the way in which we govern ourselves is rather careless and not very principled. And it allows us to mutate endlessly without actually getting anywhere. That's why I favour constitutional reform. I think that the political decisions that are made have to be made within certain boundaries that are laid down that everyone has agreed about. Well, not everyone, but which are the rules. Because one of the things about a democracy is that when decisions are made, they are binding on everyone, whether you agree with them or not. And so the question of how we ought to tame market forces is a question for politics in the end. You aren't going to be able to lay down in a constitution exactly how every decision should be made. What you have to do is to lay down the limits within which decision making can take place. And in that process, you have to respect a number of things. The Treaty of Waitangi, the provisions of the Bill of Rights, the way in which the Parliament works, which should be known and ascertainable. All those things are very important. One of the complexities of New Zealand relates to the expression, the Crown. The Crown. Well, the Crown is a very complicated entity. The Crown wears many hats. It's not just the crown on the head of the Queen. It is, in a sense, the government. And how do you distinguish the Crown from the government? Where does one start and the other end? The Crown is also the principal part of the justice system. The judges are Her Majesty's judges. The Queen is the fountainhead of justice. The public service operates in the name of the Crown. And so the Crown is the head of state as well. So you see, these ideas merge together. They become quite complicated and people don't understand them. It's not surprising. Well, it's changed fundamentally, there's no doubt. When I grew up in Nelson, in the South Island, in the 1950s, it was an exceedingly homogeneous white society. And it was bound together by a whole lot of customs. You didn't need law. There was such social conformity that you could go out and for a whole day and leave your front door open and no one would rob you. These are different times. New Zealand is now a remarkably heterogeneous and diverse society. The number of Māori will be exceeded by the number of Asians, according to the Department of Statistics, by 2038. This whole society has changed. You can't expect everyone to have a shared set of values in circumstances like that. That is why you need to pay more attention to your loose constitutional arrangements, so everyone knows what rules they are playing under. And it's very hard for them to find that out right now. Well, I think the income disparities become far too great, and the difficulties with things like housing and healthcare and access to fundamental things and low wages have all combined to say that market solutions don't actually bring social justice, and that social justice requires a shared set of values that you're going to look after everyone in some sort of way. And I think we are beginning to lose that. We haven't lost it yet compared with the way many societies are. But when you've got such a diverse group of people, you can't expect them to believe in the values of our forefathers when their forefathers were different.